Cable TV, are you ready?
Yes, sir, we are ready.
Oh, good morning or good afternoon.
Good afternoon.
Before we start, let me just apologize to everyone. I was told that one of the witnesses was teaching until 12:30, so I got the slows. Let us start in a moment. Don't look at me that way, council member. I got the slows. But I've pulled it together. So if we're ready, let me call this hearing to order. I am calling to order this hearing of the Committee of the Whole of the Council of the District of Columbia. I am Phil Mendelson, Chair of the Committee of the Whole and Chair of the Council. Today is Wednesday, September 28th, 2022. The time is 12:42 in the afternoon, and this hearing is on three bills. Bill 24-445, entitled the College Student Athlete Compensation Amendment Act of 2021. Bill 24-455, entitled the Uniform Athletes Agents Act Amendment Act of 2021. And Bill 24-456, entitled the Uniform College Athlete Name, Image, or Likeness Act of 2021. These three bills obviously are similar and addressing the issue of college athletes or college athletics. Bill 24-445, the College Student Athlete Compensation Amendment Act of 2021, which was introduced by Council Member Henderson, would permit student athletes to earn compensation for use of their name, image, or likeness, otherwise known as NIL, prohibit compensation for endorsements of restricted products or activities, such as tobacco or gambling, prohibit pay-for-play incentives, such as payments to induce attendance, and enable universities to put rules around name, image, or likeness, again, NIL compensation that protects their intellectual property and contractual relationships. Bills 24-455 and 456 are both uniform bills that were introduced at the request of the district's delegation to the Uniform Law Commission. Bill 24-455, Uniform Athletes Agents Act Amendment of 2021 comes from the Uniform Law Commission and has seen adoption in 18 states. This bill seeks to expand the definition of athlete agent, to provide reciprocal license registration for athlete agents, require athlete agents to notify universities before contacting student athletes, prohibit certain actions a student athlete can take on behalf of an agent, provide a right of action against an athlete agent for conduct violation, and maintain university eligibility if unsuccessful in a professional draft. Bill 24-456, the Uniform College Athlete Name, Image, or Likeness Act of 2021, would provide a comprehensive uniform framework for state-level regulation of name, image, or likeness activities that will provide college athletes with robust protections for their NIL rights, while also ensuring parity for competing institutions across state lines. This bill comes from the Uniform Law Commission. My thinking, depending upon the testimony today and any comments we receive thereafter, is probably to combine the two uniform bills into one and to include the portions that we like from Bill 24-445, so that out of this hearing would come one bill before the council. The record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on Wednesday, October 12th. Before I turn to the witnesses, I'm going to recognize Councilmember Christina Henderson, the author of one of the bills, if you have any opening statement.
Thank you, Mr. Chairman. I introduced the College Student Athlete Compensation Amendment Act of 2021 to respond to the changing landscape for college athletes following rulemaking by the NCAA permitting student athletes to be able to be paid for publicity and endorsement deals, more commonly known as name, image, likeness deals. Until last summer, the NCAA had maintained a very strict policy that to preserve the model of amateur athletic competition, college athletes needed to remain unpaid for their athletic performance while also avoiding paid publicity. However, the NCAA has lifted its blanket prohibition on name, image, likeness compensation and subject to boundaries set by state law. Obviously, the district, although not a state, we are a jurisdiction, and I felt like we needed something in the in-between. The bill as introduced would broadly permit student athletes to earn compensation for NIL, but provide some what I would call guardrails in terms of prohibitions. So, for instance, restricting products or activities, endorsements of products or activities such as alcohol, tobacco, gambling, performance enhancement drugs, or adult-only entertainment. It is also maintains the prohibition on things like pay to play for performance or payments to induce students to attend a particular school. This legislation would enable universities to put reasonable rules around NIL, and my staff having conversations with the consortium and others thereafter. I know that some folks would like no guardrails whatsoever. I'm not there, but happy to listen to more testimony to determine what's best there. I know that certain states who were first out the gate to introduce NIL legislation have perhaps made some changes since then. But again, I feel like if everyone is going into this conversation thinking about what are the broad guardrails that we want around this, and that allows broad flexibility for colleges and universities to go forward, I think we can find something that works here. We worked with the consortium of universities when we were putting together our bill, Mr. Chairman. So as you guys are sort of thinking about what you use as the base or not, I hope you take that into consideration. So thank you.
Thank you, Councilmember Henderson, and we will take that into consideration. So I'm going to invite all the witnesses in. I believe 4 of them are affiliated with the Uniform Law Commission, and the first witnesses with the consortium. So Mandi Kumbula Frazier, who's Vice President of Government Relations and General Counsel with the Consortium of Universities of the Washington Metropolitan Area. James McKay, who's Chair of the DC Uniform Law Commission. Libby Snyder, who's Legislative Counsel with the Uniform Law Commission. Gabe Feldman, who is, in addition to being a professor, served as the reporter for the Uniform Law Commission's Uniform College Athlete Name, Image, or Likeness Act. And Jerry Bassett, who is a Uniform Law Commissioner from the state of Alabama. If it's all right with everyone, I'll hear testimony in the order I just named individuals. So Mandi Kumbula Frazier will be first. Ms. Kumbula Frazier.
Good afternoon, Chairman Mendelson and members of the DC Council. My name is Mandi Kumbula Frazier, and I am the Vice President of Government Relations and General Counsel for the Consortium of Universities of the Washington Metropolitan Area. The consortium represents 21 higher education institutions and over 400,000 students in the DC metropolitan area. Thank you for the opportunity to testify regarding name, image, and likeness for college student athletes. First, the consortium shares the DC Council's goals and commitment to enable student athletes' ability to capitalize on NIL, protect student athletes from bad actors, ensure coordination between NIL policies and their impact on relationships between student athletes and their institutions, preserve the competitiveness of DC's collegiate teams, and operate in accordance with the NCAA's rules and regulations. We are very grateful to Councilmember Henderson and her team for the collaboration on her bill. In particular, the consortium welcomes the financial literacy components because we see strengthening student athlete education as a critical part of any institution's NIL program. We also recognize and appreciate the efforts of the Uniform Law Commission to bring some uniformity to this area of state law throughout the country. However, given that the NCAA changed its rules in order to allow students to accept NIL income, and the NIL landscape is evolving so rapidly, it is the consortium's position that legislation in this area is unnecessary and runs the risk of having unintended consequences that would restrict opportunities for DC student athletes and make DC teams less competitive. Over the last several months, there has been a clear trend towards states allowing institutions more flexibility around NIL versus less. For example, the state of Alabama, which at one point had one of the most expansive NIL laws in the country, repealed it some months ago because they found it to be too restrictive and it hindered the recruitment of talented student athletes. As a result, student athletes can still receive NIL compensation in Alabama. However, they only have to comply with 3 regulatory schemes: the NCAA NIL policy, the internal policies and procedures of their educational institutions, and the Athletes Agent Act. If the district decides to move forward with legislation, the consortium offers to work very closely with you and your staff to make a few modest tweaks in order to ensure the final legislation achieves our shared goals. For example, there is concern that the ULC bill includes language that might overly restrict the ability of institutions to regulate and coordinate with student athlete NIL activities, limit student opportunity, and disadvantage opportunities to recruit student athletes. Best practices regarding institutional involvement have evolved significantly as of late, including setting up marketplaces to promote NIL deals for student athletes, such as advertisements, social media posts, and even event appearances. This model was not anticipated when the ULC and Councilmember Henderson drafted their bills. If the council is committed to passing NIL legislation, the consortium welcomes the opportunity to work on language for both Councilmember Henderson's bill and the ULC bill. Any legislative language in DC should be flexible enough to ensure that our institutions can provide top-line NIL opportunities to our student athletes within the rules and regulations established by the NCAA. This will protect our student athletes, ensure that DC collegiate athletic programs remain competitive with peer institutions, and ensure that institutions have the ability to properly coordinate NIL activities with student athletes. Thank you so much for your consideration.
Thank you. Thank you, Ms. Kumbula Frazier. I'm going to go through all the witnesses and then have some questions. Jim McKay.
Chairman Mendelson and Councilmember Henderson, good afternoon. I'm James McKay. I'm the chair of the DC Uniform Law Commission, and I appreciate the opportunity to appear before you today to testify on these 3 bills concerning college athletes. I'll briefly discuss the 2 uniform acts. I know that the reporter for the college athlete name, image, likeness act is on. I think he might have technical difficulties getting his picture displayed, but he is on the call. But anyway, and I'll certainly defer to him about the specifics of that act. And after discussing each of the 2 uniform acts, I'll point out some of the differences between the acts and Bill 24445, at least briefly. Bill 24455 would enact the revised Uniform Athlete Agents Act. I'll call it the revised UAAA to make it easy. I see Professor Feldman is now on. That's great. And the council enacted the Uniform Athlete Agents Act, I'll say the UAAA, over 20 years ago, and it has been enacted in 40 states. It has been a great framework for protecting student athletes. Between 2015 and 2019, the National Conference of Commissioners on Uniform State Laws, which I'll call the NCUSL, work on amendments based on the change the bylaws of the NCAA that gives student athletes more flexibility in deciding whether to join a professional team or to continue with their sport in school. And it's been enacted so far in 19 states. It'll be soon 20 when the governor of Maine signs the bill on his desk. I won't spend much time going over the principal amendments. They are in my testimony, but it does a lot of important updates, the clarifications of the current law, which has been enacted in districts in 40 states. And they're listed in my testimony, but basically they enhance the requirements for agency contract. They expands the definition of athlete agent to include people who actually function as athletes agents. And it provides a lot of updates based on the 20 years experience with the Uniform Act in 40 states. It also prohibits an athlete agent from encouraging another individual to take action that the athlete agent would not be able to do. And it gives the student athlete a civil right of action against an athlete agent for conduct in violation of the act. I have listed a number of differences between the Uniform Act and Bill 445 in my testimony. I won't repeat them all here, but basically there are a lot of, it's really kind of funny. The Bill 445 seems to have adopted a lot of the old definitions in the UAAA and has not taken the definitions in the revised UAAA. For example, the UAAA has a blanket exemptions for any certain relatives of the athlete agent, but it turns out after 20 years of experience that a lot of these relatives are functioning exactly like an athlete agent and therefore should be covered. However, the RUAAA does allow them to give advice, or coaches to give advice to the athlete agent, as long as it's not for compensation. So it tries to fairly balance all of these competing needs. Now, the Bill 24456, the Uniform College Athlete Name, Image, or Likeness Act, which I guess we'll call NIL. We call it UCANALA, the acronym for the Uniform Act. It was completed by the NCUSL last year, and to allow the college students to take advantage of their name, image, or likeness, while also providing reasonable protections to educational institutions, athletic associations, and conferences. And it certainly is an improvement. It provides a comprehensive, uniform framework for state-level regulation of NIL that will provide the college athletes with robust protections of their rights, and also creating a level playing field for college athletes and institutions competing across state lines. And it corrects competitive imbalances created by a patchwork of inconsistent state name, image, and likeness laws, which Professor Feldman will give you much more detail about. And it would benefit both college athletes and college-level educational institutions in the district. And I've noted about 16 differences between UCANALA and Bill 24455. Again, I'm not going to repeat my written testimony, but they're extensive. I mean, for example, Bill 24455 it calls itself a college student bill, but it basically takes the definition of college student from the definition of student athlete in the UAAA, which of course has a much broader application. It includes high school students, for example, and so that's not a very good idea. And certainly, another thing is it includes a definition of fair market value. The UCANLA drafting committee considered defining fair market value, but decided against it because it would lead to unnecessary litigation. I mean, it's whatever fair market value is, whatever somebody wants to pay. It's almost impossible to measure. You've got an evolving landscape, including differences in value based on the student's location, sport played, and social media followed. We felt it would be a mistake to do that. The definition of compensation, this is kind of a fundamental thing. Bill 24455 proceeds on the mistaken assumption that a college student athlete's right to earn name, image, or likeness compensation must be expressly authorized by a state statute, but that's not true. They already have the right under federal trademark and copyright statutes and the right under the district's common law. But they've been prevented from taking advantage of that because by policies of the NCAA. The UCANLA assumes, it's written on the correct assumption that the students have these rights and that they need a framework for them to take advantage of these rights. I'm just trying to see basically there are quite a few other important differences which I've listed in my written testimony, and for example, the Bill 445 lists categories of nil activity that are prohibited: alcohol, tobacco, steroids, gambling, and things like that. The UCANLA takes a different approach. Instead of categorically restricting activity by college athletes in certain areas, it allows institutions to adopt a policy to prevent name, image, or likeness activity that the institution determines would have an adverse impact on its reputation, provided that the institution complies with the same policy with respect to the institution's sponsorships. So I think that this is a fair way, and it's a much more reasonable way of approaching this issue. And I don't want to. One final important difference is that the Bill 24455 does not include any provisions for registration of third parties. A very important, I think, part of UCANLA. It contains a robust registration regime for third parties engaging in nil activity that is the same as the registration regime for athletes agents under the RUAAA. And it integrates this together. In other words, this act was drafted by a lot of the same people, and I think it had the same drafting chair as both these bills, 455 and 456. Work together. They were designed to work together, and I think it'd be fine for them to be combined in a single bill because they are very closely related. Final thing, the Bill 445 does not include any provision on civil remedies for college athletes. UCANLA contains a provision that clarifies the circumstances in which college athletes or institutions have or do not have a civil remedy. I think it's a very important clarification instead of leaving it to a case-by-case basis. Therefore, I urge the committee to report favorably on Bill 24455 and Bill 24456. And I would be glad to work with the committee and with Councilmember Henderson and with Ms. Kamula Fraser to see if we can create a single bill that would address all the issues of concern. It's a very important bill for the youth of the District of Columbia to have this protection of their rights. So thank you very much. I would be pleased to answer any questions at the appropriate time.
Thank you. Thank you, Mr. McKay. Libby Snyder.
Thank you very much, Chairman Mendelson, and thank you, Councilmember Henderson, for your bill as well. My name is Libby Snyder, and I'm a staff attorney at the Uniform Law Commission. I'm here to testify in support of Bill 455 and Bill 456. But before I get to the specifics of those bills, I wanted to give a very brief overview of the Uniform Law Commission's robust drafting process. Typically, what happens with the Uniform Law Commission with all of our bills is it starts with an idea that is generated either by one of our commissioners or by an outside stakeholder. And that idea is submitted to what we call the Committee on Scope and Program. If that committee feels it's an idea where a uniform law might be beneficial, they'll form a study committee, which will take typically a year to study an issue. And if that study committee feels it should become a uniform law, they will move it to a drafting committee. A drafting committee is comprised of commissioners and a reporter. We have two of our reporters here, Jerry Bassett and Gabe Feldman. And the reporter is a national expert who takes the opinions and ideas of the committee and drafts it into a law. Committees are also comprised of many, many stakeholders called observers. And these people are, they may represent outside organizations that have a unique interest in the area that the uniform law will be drafted on, people who will be affected by the final drafting project. And the number of observers that we had for the revised Uniform Athlete Agents Act, which Bill 455 would enact, we had dozens of observers, coaches, athlete agents, athletic associations, professional leagues, university athletic departments, and compliance officers, state agencies, and others. We had a similar scope of types of observers for the Uniform College Athlete Name, Image, or Likeness Act, which is Bill 456, but we had even more. We had over 100 observers, and in that group, we also had a dozen current student athletes. And all these stakeholders were present at our drafting committee meetings, and were able to give timely input on the uniform laws as they were being drafted by the committees to make sure that what we ended up with was a consensus product. What I'm going to do is briefly go over 3 points that I think are important to discuss on Bill 455, the Revised Uniform Athlete Agents Amendment Act, and then a couple points on Bill 456, the Uniform College Athlete Name, Image, or Likeness Act. On Bill 455, as Commissioner McKay mentioned, the District of Columbia did adopt the Uniform Athlete Agents Act in 2001. And what Bill 455 will do is update that law to the revised Uniform Athlete Agents Act, which was drafted in 2015 and then further revised in 2019. The 3 main points I really want to hit on this act are first, the changes in the definition section. And to me, this is really the heart of the act, the key of what these revisions do. And it broadens the definition of athlete agent to include any individual who is essentially acting as an athlete agent, not just somebody who's holding themselves out as an athlete agent. So it's anybody who is, for compensation or in anticipation of compensation, advising student athletes on finances, business ventures, NIL deals, career management, anything like that. And what we're doing is making sure that we're really covering the whole field there, rather than the more narrow definition contained in current DC law. What the new updated definition also does is it explicitly exempts anyone who is a licensed, registered, or certified professional acting within the scope of their licensure, certification, or registration. So if you're an attorney working with a student athlete, as long as you're providing that student athlete with services that you would provide to any other client of yours, you don't have to register as an athlete agent. You would only have to register if you're treating that student athlete client differently than any other client of yours. And then what we also did was we removed that blanket exemption for spouses, parents, siblings, grandparents, or guardians. Because as Commissioner McKay mentioned, we found that in some cases they are actually acting as an athlete agent. And what we did was we added back in a slightly more narrow exemption into a new defined term, recruit or solicit. And what we said is you're not recruiting or soliciting if you're giving advice in a familial or coaching situation, unless you're giving that advice in anticipation of compensation from an athlete agent. So what we really wanted to do was, parents, guardians, coaches, they can advise student athletes in their lives. but only if they're doing it in the student athlete's best interest and not because they're going to be receiving compensation from some other party. The second key point on the revised Uniform Athlete Agents Act is that it gives student athletes a cause of action against an athlete agent acting in violation of the law. Current DC law, drafted based on the Uniform Athlete Agents Act of 2000, only gave educational institutions a right of action against athlete agents or student athletes acting in violation of the law. What we found is that in many cases, the student athlete is also being harmed by the actions of an unethical athlete agent who is violating the law. And so we wanted to make sure that those student athletes who are harmed do have a cause of action. And finally, the revised act adds some true reciprocal registration provisions, which in my written testimony, I talk about this a little bit more, but what we've seen is that in the pre-NIL era, most student athletes never worked with an athlete agent. They only worked with them in a very narrow context, and their chances of losing eligibility were high because of strict NCAA rules on activities with athlete agents and student athletes. In the post-NIL era, we're seeing that any college athlete can work with an athlete agent. And so that business is booming. We're seeing a real increase in the number of athlete agents registered across the country. For example, in Florida in 2019, there were 328 athlete agents registered. And then in 2022, there's 557. So we're seeing a real increase in the number of athlete agents acting out there. And so, based on the increase in activity and some of the necessary changes the Uniform Law Commission made over the past 20 years, I think Bill 455 makes some really necessary changes to the law. And then on the Bill 456, the Uniform College Athlete Name, Image, or Likeness Act, I'm going to really leave most of this testimony to Gabe Feldman, our brilliant reporter. But I just wanted to state that there are some tweaks that the Uniform Act makes that are different from Bill 445 that I do think provide more rights and more flexibility to the college athletes while still providing those guardrails that are really important. The first is that it prohibits educational institutions from limiting specific types of NIL activities, like we mentioned, tobacco, gambling, alcohol, unless that educational institution also does not engage in NIL activity on those same areas in their sponsorships. So a university can't say, student athletes, you may not enter into NIL deals with Budweiser unless the university is also willing to not enter into any NIL deals with alcohol companies. We think it's important that they're playing by the same rules and they're being held at the same standards. But to balance that, UCANALA does allow the institution to prohibit NIL activity that's illegal. So, a college athlete under the age of 21 wouldn't be able to do that deal with Budweiser. And then, to me, one of the more important parts and why UCANALA and the RUAAA slot together so well is that they harness those same registration provisions for athlete agents so that we're not duplicating efforts and we're making it a little bit easier to comply. So with that, I'd be happy to answer any questions that the council has. And I'm happy to work with anybody involved in combining these bills. And I thank you for your time.
Thank you, Ms. Snyder. Mr. Feldman?
Good afternoon, Chairman Mendelson and members of the committee. My name is Gabe Feldman, and I served as reporter for the Uniform Law Commission's Uniform College Athlete Name, Image, or Likeness Act. I am the Cher Garner Professor of Sports Law at Tulane Law School and the Paul and Abram B. Barron Professor of Law at Tulane Law School. I'm also the director of the Tulane Sports Law Program and the co-director of the Tulane Center for Sport. And I also serve as Tulane's Associate Provost for NCAA compliance.
Before you go further, what is a reporter?
So the reporter is essentially the drafter. When Ms. Snyder mentioned earlier that there are a series of observers and then commission members, and there is a drafter that is appointed that they call a reporter to help actually draft the legislation or the act in response to feedback from the commission members and all of the observers.
Thank you.
And I appear before you today to testify in support of Bill 456, the Uniform College Athlete Name, Image, or Likeness Act of 2021. You have my testimony before you, and so I won't repeat what's written there, but I do want to highlight a couple of points, some that are, I think, foundational and help provide context for UConilla and for the conversation that we've had today. The first is what was in large part driving the change to allow college athletes to receive compensation for their name, image, and likeness. And there were a lot of factors involved in terms of what we're seeing as unnecessary restrictions on college athletes earning money for their name, image, and likeness. But what really brought it to a head in a lot of ways over the last few years was the explosion in name, image, and likeness opportunities for students, not student athletes, for students, for celebrities, for social media influencers, where we traditionally had big celebrities getting paid large amounts of money to endorse brand name products. We still have that, but really now we have thousands of people across the country and across the world, hundreds of thousands of people who are making money from social media appearances, who are making money posting TikTok videos or doing small advertisements on YouTube and the like. And the only people in this country that were categorically denied the right to make money off of their name, image, and likeness, or to put it differently, the only people who were categorically denied the right to make money from the right of publicity were college athletes. If they wanted to be eligible to participate in college athletics, they were not allowed to make money off of their NIL. And so that's why you saw states, starting with California, step in, and as Commissioner McKay said, not to affirmatively establish a right of publicity, but instead to prevent the NCAA from restricting the college athlete from exercising their right of publicity. And that's why we've seen these state laws pop up. And that's why I think it's, as a fundamental matter, important for a state to have a law to continue preventing the NCAA or other organizations from restricting college athlete name, image, and likeness. Now, as you've heard, the NCAA did loosen its restrictions. They have instituted an interim policy. And I just want to highlight that that interim policy does still have significant restrictions in place. And those restrictions are, one, that college athletes still may not be paid for their athletic performance. Two is that name, image, and likeness money should not be used as a substitute for pay for play or as a recruiting inducement. And then three, that the universities themselves are prohibited from paying the college athlete directly for the use of their name, image, and likeness. Those are significant rules that are still on the books. Whether or not there is a state law in place, those are rules that could be enforced. The NCAA has been a bit lax in enforcement of those rules, but those rules are still in place. And really what the NCAA was trying to do, and what states have been trying to do, and what we would recommend that DC does, is put college athletes on the same footing as non-athlete students on campus, recognizing that there are some differences between college athletics and college music or college theater, that there are some reasons to try to put some restrictions on what college athletes are doing to maintain a level playing field, to maintain the uniqueness of college sports as different from pro sports, to prevent the payment being used as pay for play or as recruiting inducement. But short of that, we want to provide the college athletes as many rights as possible so that they are just like non-athlete students on campus, so that they can fully exercise their right of publicity. So what the commission really looked at is what restrictions are necessary and what guardrails are necessary to maintain the integrity of college sports, to protect the college athlete and to protect the institution, while also giving the college athletes as many rights as possible. And that's why there are certain restrictions that are put in place. That's why there are certain guardrails that are in place to protect the college athlete, to protect the institution, but also to allow them to compete on a level playing field with other institutions. What we've seen, and what has been mentioned a couple of times, is with individual state laws cropping up, we've seen this patchwork, and we've seen significant inconsistency from state to state. And that's problematic on a very basic level, that in a lot of ways, what defines college athletics and pro athletics is uniform rules. that all the athletes are competing under the same rules, and then may the best man or woman win, may the best team win. We don't want these rules to be used to influence the outcome of the game or to give one school or one state an advantage over another. And what we've seen is an inconsistency, which has led to recruiting advantages, but has also led to a lot of confusion among athletes, among donors, among institutions on what is permitted and what is not permitted. And so it's part of why we believe that a uniform law is so important. And why, more specifically, we believe that Bill 456 is so important is that it does a number of things to protect both the college athlete and the institution. I laid out in my testimony some of the differences. I think Commissioner McKay did a wonderful job in his testimony of laying out the differences. Ms. Snyder did as well, and Commissioner Bassett did as well in terms of the Agent Act. So I don't want to go into too much detail on any of the individual differences, but I do want to highlight one of the changes that Ms. Kumbula Fraser mentioned in her testimony, her written testimony, and that the sort of unforeseen development, which is the growth of these collectives, which are groups of donors that have come together, pooled money, and in many cases are pooling the money really in an attempt to recruit an athlete to attend the school or to convince them not to transfer. And we're seeing that across the country. If that NIL money is being used as a recruiting inducement, or if it's being used as pay for play, it is prohibited under NCAA rules. That should and could lead to ineligibility. There are many schools who are trying to be as careful as possible about making sure that that NIL money is not being used as pay for play substitute or as a recruiting inducement. They are also trying to distance themselves, the institutions, from these collectives, because the closer the institution is to the collective, then the more likely it might look like the institution is the one paying the compensation for the use of the athlete's name, image, and likeness, which again is in direct violation of the NCAA's current rules. So I think we want to be careful, although we want the athletes to have rights, we don't want to open up the law so much that it could endanger the institution and the athletes by allowing or facilitating the institution to do something that would clearly violate existing NCAA rules. And
Let me interrupt. You were talking about the collectives. I'm not sure I understand what those are. Can you describe that better?
sure, yeah, there is, if you think about in the old days, I mean 14 months ago, there were boosters, and the boosters were typically wealthy donors, wealthy alum who wanted to see their team succeed. And so they would donate money to the athletic department to help build a new facility, to help fund a coach's salary, whatever the case may be. Once NIL was permitted, a lot of these boosters either put in additional money to say, we not only want to help build a facility, but we want to pay our college athlete money for the use of their name, image, and likeness to promote our brand, to promote a charity. The next step was we had boosters come together, and those boosters came together to form collectives of boosters. So if you had booster 1 through 20 at University of Alabama, they would come together and form a collective of boosters. They would pool their money, and their pooled money would be used to pay college athletes for the use of their name, image, and likeness, either to promote the collective or to promote the individual businesses that made up the collective, or to promote some charity. And so what we are now seeing at most FBS schools, at many Division I institutions, collectives have formed. They're separate from the institution, but they are trying to generate money to be used to pay college athletes for their name, image, and likeness. Again, either to try to prevent them from choosing to transfer away, or to convince them to transfer in, or to recruit the high school athletes. Does that make sense?
Yeah, I think so.
Okay. And so there are a lot of red flags that are raised by the collective activity, particularly when you see one collective, for example, paying $8 million for a college quarterback, ostensibly to attend the university. And there are not, whether you want fair market value or no fair market value, you don't have to be a marketing expert to conclude that $8 million in name, image, and likeness money for an athlete who's never stepped foot on a college football field is not legitimate NIL money. it is being used as a recruiting inducement, it is being used as a pay for play. The NCAA is looking at that those types of deals are potentially in violation of NCAA rules. They would also be in violation of Bill 456 and many of the state laws that are passed, because those rules prohibit money being used for pay for play as a recruiting inducement. And again, it may be difficult to draw the line between a legitimate NIL deal and pay for play. In many cases, it's not in that type of case. It's not difficult to say if you're getting paid $1 million for one autograph, that's not a true NIL deal, and that we want to prohibit that for a variety of reasons. In terms of the institutional involvement, though, and because I know that's one of the drivers behind the consortium wanting a more limited law or not wanting a law at all. And there was mention of best practices of institutional involvement emerging. I would caution thinking about what's emerged as best practices, because one, the landscape is still so in its infancy, and schools are still trying to figure out what to do, why to do, and how to do it. And they are also terrified of liability. And they are terrified of liability in a few different ways. One is by paying the athletes for their NIL compensation, which could lead to a major violation, and then subject the school and the athletes to discipline from the NCAA. Two is the risk of closer and closer involvement with some of these very unregulated, and I'll talk more about the lack of regulation in a second, third parties, where we don't know what these third parties are doing. We don't know what they're doing to have the money to pay these athletes. We don't know what they're then requiring the athletes to do. We don't know what they're necessarily doing with their name, image, and likeness. There's very little control over that. I think there's a lot of risk if the institution becomes more involved with that as opposed to less involved with that. And then the last piece, and there are other pieces, other risks raised by this, are Title IX. The more the institution becomes involved with NIL deals, the more likely it is that Title IX would apply. And if Title IX applies, it would require the institutions to ensure equity across genders in terms of NIL opportunities, NIL promotion, and publicity. Right now, that's not happening. And it's not happening because Title IX doesn't apply, because these are these independent third parties, and Title IX does not apply to them. If the institution gets more involved, then we also have to worry about Title IX. We have to worry about a lot of different areas of liability for the institutions. Last couple of quick points I'll make. One is on the idea of marketplaces and marketplaces helping college athletes. I still think it's debatable how much value the marketplaces are bringing, but let's assume for sake of argument that they are valuable. Many states that have restrictions on institutional involvement have marketplaces that have been set up. Here in the state of Louisiana, our state law prohibits institutional involvement, but we have a marketplace here at Tulane. And if we have it here at Tulane, there are many schools in many states that have much more NIL activity, that have bigger marketplaces that have been permitted despite the state law prohibiting institutional involvement. So I don't think it's necessarily a prohibition on these marketplaces if you prohibit the institutional involvement. The last piece I'll mention, and I think is maybe the most significant feature of UConilla that hasn't been emphasized, been mentioned today, but hasn't been emphasized, and that is the requirement that these third parties register. And those third parties would include, originally we thought it would be the mom and pop bagel shop or donut shop, that we wanted to make sure that they were treating college athletes appropriately and properly. It might be the individual boosters. It might be the Nikes, the apparel companies of the world. But now we've seen it's primarily the collectives. The collectives are completely unregulated. And for all of the reasons that we want to continue regulating agents, we also should want to regulate these third parties. Because as Libby mentioned, it's, that we are now seeing more and more agents because there's more opportunity for them to make money off of these college athlete NIL deals. But for every athlete who is represented by an agent in doing an NIL deal, there are probably 100 athletes who are not represented by agents, who are doing deals directly with these third parties. And again, there is no oversight over these third parties. So if we want to protect college athletes and we want to protect institutions, I think we need to require some oversight, some registration, some transparency, some disclosure of what these third parties are doing. Because the Wild West right now is primarily with these collectives. The lack of control is primarily with these collectives. They have been invited to do business directly with our college athletes, with no oversight, with no reporting, with no disclosure. I think that is a recipe for disaster. I think it's only a matter of time before athletes are hurt by that. And then I think it's only a matter of time before institutions are hurt by that, which is why I think the cause of action, the civil remedy is so important to give to the institution and the athlete if one of these third parties does something to harm the institution, to harm the athlete, to harm their eligibility. So I will stop there. I am happy to answer any questions, also happy to work with members of the committee on any legislation that might come out of this, and would just end by saying that I support the passage of Bill 456, and I thank you for your time.
Thank you, Mr. Feldman. Mr. Bassett.
Good afternoon. My name is Jerry Bassett. I'm a Uniform Law Commissioner from Alabama. In real life, I'm a bill drafter for the Alabama legislature. And I was a member of the original UAAA drafting committee in 2000. I was reporter for the RUAAA in 2015 and 2019. Libby and Jim and Gabe have done a pretty good job of explaining the necessity for updating the UAAA to incorporate the changes that were made to modernize it in 2015 and 2019. And to the extent that they didn't, I've done it in fairly extensive detail in my written testimony. So I'm willing to, rather than beat the dead horse, I'm willing to answer questions, and like everybody involved in the process, I am more than happy to help do whatever the council decides that is appropriate to assist in that process of getting to where it is that you want to get. Thank you very much for the opportunity. I appreciate it.
Thank you, Mr. Bassett. So I'm going to ask a few questions, and I'll turn to my colleague, Councilmember Henderson. Ms. Kumbala Frazier, you went first, so I'm going to ask you first. At the end of your statement, you say any legislative language in DC should be flexible enough to allow for institutional involvement in NIL activities. What does that mean?
So what we were talking about is to provide top-line NIL opportunities. For example, if you had institutions, as I mentioned earlier, who wanted to put together a marketplace in order to promote their students and provide access for students to have event appearances or sign autographs or participate in advertisements. So that's what we were talking about, having some flexibility there.
And you see that prohibited in the uniform bills?
Well, there is language, and if you give me just 1 second, in one part of the ULC's bill, which would prohibit institutions from assisting, identifying, arranging, facilitating, developing, operating, securing, or promoting name, image, or likeness activity. And so that was the language that we were concerned about, which it's interesting to hear the professor say that he does not think that that would prevent a university from being able to develop a marketplace. We saw it differently, so I'd certainly love to hear more.
Well, why don't I turn to Mr. Feldman?
Yeah, so what we've seen develop across states, and again, in states that have laws that specifically prohibit institutional involvement, is that those institutions and those states have determined that setting up the marketplace does not constitute institutional involvement, that it is just setting up the framework so that the athletes can then get the deals with these third parties. But it would be akin to having a career day for your college athletes, where you invite in potential employers, and those potential employers are able to meet with your college athletes. which is different than the institution itself trying to find employment for particular athletes. That it is enabling them to do deals more easily, but it's not seen as facilitation of deals. And so that's when I mentioned Louisiana, there is that prohibition in place. Other states have that prohibition in place. I think Commissioner Bassett might be able to talk more about what happened in Alabama and the repeal of Alabama's law. But there are more or less restrictive state laws and some with no state laws whatsoever. But we have not seen schools not create these marketplaces because of the institutional involvement language.
So before I turn to Mr. Bassett, what you're saying, Ms. Kumbula Frazier, is that you see some language in that. Could you tell me where in the bill?
Sure, let me tell you the page number. It is page number 8. And if you go down to
Line 188?
section C, yes, 188 and 189. Yes, Chairman.
Okay, and Mr. Feldman says that he's not reading it as strictly as you are. Does that give you comfort?
It does give me some comfort. I mean, perhaps the language could be, tweaked in some way, or some language included in the committee print. But in me looking at it, and my colleagues saying promoting or identifying a marketplace would fall under promoting, because you're listing all of the student athletes and providing access to them. So if you're saying that that's not what it says, and we could make sure that there's clarification, that certainly would provide me with some comfort. But I read it differently, just in the plain language. To me, that would be promotion.
ULC acts generally come with a rather robust statement of intent. Is this discussed somewhere in the background materials?
I don't believe it is. And I think that's in part because these types of marketplaces weren't set up yet.
Very new, like in the past month or it's super new.
Mr. Bassett, you were sort of invited to talk about Alabama.
Yeah, thank you, Mr. Chairman. Alabama was a little bit ahead of the curve in NIL, adopting a state NIL law. It was the law that we adopted was law that we enacted was based on the California law, which I think was first in the country. It had the financial education provisions from the New York law added to it. And between the two of them had what we thought were reasonable guardrails to protect both the institution and the student athlete. What we found out was after the NCAA adopted their rules, which deferred to state rules, that there were states that were adopting NIL language with no guardrails and no restrictions. I've not actually seen it, but I've been told by several people that there's actually a provision in the Florida law that says that their bottom line is whatever the bottom line is any place else in the country. That just put us at a competitive disadvantage in recruiting. Other states could offer things that we couldn't offer. And so we repealed the law that had us at a disadvantage. And I don't know that we're going to reenact a law. Actually, I only write them. I don't get to vote on them or introduce them. I don't know that we're until something is done that puts everybody on the same, as somebody said earlier, we all ought to be playing by the same rules. And the rules ought to be reasonable, have guardrails. It can't be the wild, wild west, which is what it's getting to look more and more like.
So you mentioned, in addition to Alabama, California, New York, Florida, are any of those uniform laws?
No, they were all done prior to the UConilla. The uniform law was just adopted in 2021. And the California law, I think, was enacted in either 2019 or 2020. And New York and someplace else up in that area were fairly shortly thereafter. And I think Florida was about the same time.
Okay, so UConilla, I hate to use your term, was adopted by the commission in 2021.
Yes.
How many states have adopted it so far?
I don't think anybody has adopted it, but Professor Feldman can, whatever, or Libby Snyder would know better than I. I know that we have not adopted it in Alabama.
Ms. Snyder, do you know?
Yeah, we don't have any states that have enacted UConilla yet. I think that the nature of things across the country sort of were thrown into a tailspin when the NCAA issued its interim NIL policy, and many states were sort of waiting for the dust to settle before deciding what to do. And as Professor Feldman said, you know, it's still the wild, wild west out there. And, you know, despite this NCAA interim policy, that hasn't really put in place any guardrails, and there is still a real need for legislation. And so I think that there will be interest. Yeah.
How many states has it been introduced in?
Only DC and Washington State.
And where's Washington State with this?
It did not make it through before they adjourned for session.
Did it make it through either house?
Yes, it made it through the Senate.
Okay, so just to kind of go back, Ms. Kumbula Fraser, your statement, any legislative language should be flexible enough to allow for institutional involvement. You spoke to then, what you meant by that was to set up events for athletes?
Chairman, yes, for example, there is a site called Open Doors, which has become very, very popular. And what they do is they list every single, well, at least some universities are having, where they list all of the different athletes. And if you click and you have the picture of the person, you click on it, it allows you to click if you would like to pay the person to give an autograph, or to appear in an event, or to provide a social media post. So it's almost kind of advertising each student and how much they would charge for those particular services.
And who does Open Doors?
It's called Open Doors. I know University of Maryland, which is one of my consortium universities, does it, and it made quite a splash. Off the top of my head, I don't know how many other universities are also doing it. I understand that it's happening in Louisiana, as the professor also mentioned. So,
But you're talking about that kind of event.
yes,
Well, it also could be an event itself.
it's the website. It's the website.
But it also could be like an in-person event. So let's just say UDC and George Washington University, getting into the district, getting away from Maryland, that they want to do an open house to meet athletes, and I guess to help encourage folks to pay for their name, image, and likeness, something like that.
It's almost like I'm trying to think of a site that's kind of comparable, but it is advertising the name, image, and likeness prices for each particular person. And you would go, and I understand that I see that Councilmember Henderson just put it into the chat. And let's say, Chairman, just for using you for example, if I wanted to hire you to appear at an event, I could go to, let's say you went to X university, I could go to their website, click on you, click on your name, decide I want to hire you for that, click on that, and you would be able to facilitate opportunities, NIL opportunities for all of the student athletes in a particular university. They all have different prices and charges depending on perhaps popularity of certain students and their marketability, but the universities are helping to promote those by including those websites on the university sites.
Was there anything else you were thinking of when you said that legislative language should be flexible enough to allow for institutional involvement in NIL activities?
That was the main one. That was the main one that I was talking about. That's the one.
Okay. Let me just note for the record, that you probably would lose money if you were clicking on my image, but you also said in your testimony, the district bills do not offer students and institutions the flexibility they both need in order to adapt to the changing landscape. Same issue or something else?
Same issue. And I hate to use the term wild, wild west, but everything is just changing so quickly, and universities are trying to keep up. And there is concern that if certain states have more flexibility, it will be easier for them to recruit talented student athletes, and that others could be put at a disadvantage. So that's kind of the dynamic there, but they don't know what's going to pop up next week somewhere else, in the week after that somewhere else. So it's a challenging situation.
So in your statement, your testimony, you said we would request some modest tweaks. You didn't actually list any specifics, but the modest tweaks would be around this single issue.
That is one of the issues. And for all we know, Mr. Chairman, there could be something else that pops up next week that we're just unaware of. And so that's why we were talking about having the flexibility, because for example, with the marketplace issue, when the ULC drafted their legislation, when Councilmember Henderson drafted hers, it wasn't even anything that was even in the realm of possibility that people were thinking about. So the universities just want the flexibility if something else pops up that they would like to do, and that it's allowed in Louisiana, Georgia, Florida, or just as the gentleman from Alabama said, they don't want to be at a disadvantage. Unfortunately, we can't predict what's going to happen next. And so that's why they were asking for flexibility.
I'm over my time. I'm going to turn to Councilmember Henderson, and even though the clock is going to ascend or descend, I'm not going to strictly hold you to 10 minutes.
Thank you, Mr. Chairman. Mondi, I'm on this open endorse site. Very, very interesting. They have athletes from, whoever has chosen to sort of participate in this, say what your like social media reach is and the whole nine, which is very interesting here. Thank you all for testifying. I have a couple of questions. Mr. Feldman, I was very interested in your testimony. I think that obviously your background in terms of sports law and understanding sort of the evolution of NIL was very, very helpful here. And in fact, I'm listening to you and I'm thinking to myself, so what we need is a federal law here if everybody is supposed to pay by the same rules. Yes?
Yes. I mean, I think we either need a federal law or we need a uniform state law. And we are trying, and Libby and Commissioner McKay can speak more about this from the ULC perspective, but trying both to get states to adopt the UCANILA so that there will be uniformity at the state level, but also working with members of Congress and federal staffers and legislators to adopt what would be a joint federalism framework where there would be federal legislation, but then also state laws that would provide some flexibility for individual states, for example, to allow for states to control agent registration, third-party registration, prohibited third-party conduct, or the type of deals you might do with those sin categories. So we are proceeding on both tracks, and it may be the only thing harder than getting a uniform law at the state level is getting anything passed through Congress right now, but we're attempting to do both.
Yeah, no, I think you're definitely right about that. But I also feel like, you know, your testimony around the collectives, right? Okay, so boosters have been doing, not all boosters are bad. However, there are some boosters who have given boosters a bad name. And so it just kind of seems to me that there's always going to be this kind of evolution of trying to get around the NCAA here, right? So this is in part why I think some general guardrails are important in terms of not just protecting the athletes, but also protecting the institution and the integrity of the sport. I'm not one who believed that, you know, in order for it to remain pure, the athletes shouldn't have been paid. No, because I feel like for some of the college games that I have seen, they have been more entertaining and displaying the same level of athleticism and commitment as you see on the professional level. And therefore, those young women and men deserve to receive compensation, especially since their universities were making millions of dollars off of them, even though they were unable to do so the same, right? You know, you sell my jersey in the team store, it may not have my name on it, but it has my number on it. But if I were to try to sell my jersey, now somehow I'm in violation of NCAA rules and regulations. So I feel like where we got here is super important. But you know, I think Mr. Bassett, to the point that you brought around Alabama and feeling uncompetitive with what was happening in Texas and Florida, is what for Alabama, or I guess the landscape now of of states who are choosing not to do anything. Are you just going based off the institutions, the NCAA plus the institutions rules? Does that make sense?
Yes, it does.
Okay. Is that the case right now?
I believe so, yes.
Okay, but if everyone is sort of, I'm not saying a race to the bottom, but if everyone is trying to recruit the best 5 stars in whatever particular category it is, don't you see a potential for a wild, wild west if we don't have some type of guardrail system in place?
Absolutely. Absolutely.
Okay. One of the reasons in the bill that I introduced that we sort of list out some prohibitions was because we were trying to align it to in areas of general practice where we are trying to keep young people out of dealing with those products anyway. So for instance, like for you to do an alcohol deal and we're not trying to encourage anyone under the age of 21 in order to drink. You know, that was part of that. I mean, in terms of the restricted products or activities, are there any, you know, Mr. McKay or Ms. Snyder or Mr. Feldman that you felt went too far?
I'd like to have Professor Feldman maybe handle that question.
Sure. I'm not sure that it's a matter of going too far, but it was more of a matter of fairness, that if an institution were going to prohibit a college athlete from engaging in some type of deal because it was against the values of the school, then the school itself shouldn't be doing those types of deals. And it's rather than listing specific categories, it does provide more flexibility. Now, there are some categories that are in there. Again, if it's illegal, you can prohibit it. But it was more fear of schools being too restrictive and not providing fairness to the athletes. So it would likely cover most of the category, many of the categories that you have specifically included, but would also provide more flexibility if the school potentially tried to overreach. And so that this was designed to protect the college athlete as much as possible.
Okay. I'm not aware of any university in the district who has a deal on alcohol. I could be wrong. I mean, I've always thought it was weird that we could be watching a college basketball game and then you get inundated with ads, Budweiser, et cetera, et cetera, et cetera, where we're talking about athletes who are not even eligible to even drink said product. But I think you're talking about a larger confluence of conflicts there. Okay. I'll leave, well, I'll leave that part there. I do feel like guardrails are important, especially if everyone is going after the same athlete or trying to get the best athlete possible. There are these unspoken incentives, perhaps, for universities to do weird things. We've seen it happen, right? We've not only seen universities do weird things, we have seen high schools do weird things to get young people to attend their institutions. And so, sure, we can like contort ourselves into pretzels to try to create a law that captures everything. And I think that's not what we're trying to do here. I just am trying to like, you know, we just don't, yeah. Okay, just give me 1 second. Ms. Kumbula Frazier, for all of the schools that are in the consortium that are in the DC in particular, have they already promulgated their own individual rules to their athletes in terms of like what is possible versus not?
Some have, Councilmember Henderson, and some have not, or are in the process of doing so. And then others are waiting to see what happens if there's going to be legislation in the district.
Okay, because I guess my question would be around, to the point around confusion. Are we introducing something that is like completely out of line with what university practice already is in certain matters?
Since, you know, for the ones that actually do have something in place, I wouldn't necessarily say that. I think that, you know, they're requesting the flexibility, and some say, well, we already have a code of ethics for our particular students, so we would be able to handle it that way internally without having, you know, legislation. And then others just have not. We have a number of universities, and they all have different levels of resources. So some have teams that have already addressed this, and some have not done so just yet.
Okay. Mr. Feldman, to your knowledge, is anyone tracking what's going on right now in the system writ large? I mean, I feel like when you have so many institutions who are able to do something different, every state is kind of doing something different. I don't know. I feel like if I worked for the NCAA, I'd be like sweating here that this is just, it took a lot to get them to this place, but then to leave it as broad as they have, I feel like we're setting ourselves up here.
Yes, and I don't want to get too far into the weeds, but part of why we're in the position we are in is because the NCAA lost an antitrust case last year in the Supreme Court, the Alston case, that called into question many of the restrictions the NCAA has placed on athlete compensation in the past. The Alston case was not about NIL, it was about education-related benefits, but the reaction to that loss and to Justice Kavanaugh's concurrence, which basically said he thinks maybe everything the NCAA is doing right now is illegal. The NCAA's response was to be risk averse and say, all right, we are not going to try to restrict anything that college athletes are doing because we don't want to get sued again. And they had a very detailed NIL policy that was drafted, and they scrapped it at the last minute and instituted this very hands-off interim policy that delegated almost all authority to individual states and to schools because they were worried about being sued under antitrust law. And so there's this push and pull between the NCAA trying to kind of maintain what it thinks it's special about its sport, but also not continue to get sued under antitrust law. And there's also been a change of leadership at the NCAA. There's just a lot of uncertainty. And right now the NCAA is, I think it's fair to say, not really enforcing many of its rules.
Okay.
In part because of the antitrust litigation.
Under existing landscape, could a student athlete sign a deal for a product that the sport does not allow? So I'm thinking marijuana related, cannabis related products.
I mean, in terms of the NCAA rules or state laws or institution rules?
That's complex. Is anyone? I mean,
So I mean, short answer is yes, that most of the policies that are in place would not allow a college athlete to endorse or do an NIL deal with a cannabis or marijuana company, even in states where it is completely legal. Yeah,
okay.
most have a policy against that. And even where things are not necessarily illegal, like a performance enhancing drug that may be legal, but is prohibited by for college athlete use, the college athlete can't promote the PED. And there's also some restrictions on even particular supplement companies who make legal substances, but also make things that have banned substances in them. So lots of institutions and states do have policies that prevent athletes from doing those types of deals.
Okay. So in your opinion, you do think it is important, or you would endorse DC doing some type of law as opposed to just leaving it to the institutions in the district to just decide?
Yes,
Okay.
absolutely. And in part because, as I mentioned, I do think the third party registration and disclosure and transparency is important, but also a lot of the other protections that have been mentioned and guardrails that are in there, I think are important. So I do think it is much better than having no state law. And although Alabama did repeal its law, other states that went early, like Florida, like Louisiana, have not repealed their laws. They have considered it, but they have decided to maintain the laws because they, when they originally passed the laws, thought that they were important to protect college athletes and to protect institutions, and still think they are important. So they have not scrapped the laws completely.
Well, given performance of some of those football teams in those two states that you mentioned of late, maybe. No, I'm kidding. Oh, and no offense, if you actually went to LSU, I know you're at Tulane now, so my bad if that was too close to home.
I went to Duke, and you can feel free to make fun of Duke football as much as you want.
All right. Thank you, Mr. Chairman.
Thank you. But I have to say that I do have some bias toward a uniform law, because even though we would be first if we adopted it this month, the idea here is to have a common law among the states, as many states as possible. And then the issue is, what adjustments do we make? Looking first at suggestions that are embodied in Councilmember Henderson's legislation. Mr. McKay, when listening to your testimony, was there any part of Councilmember Henderson's bill that you liked?
Well, yes, I mean, certainly financially, we have a little something in the UCANLA about financial literacy, allowing institutions to educate students about the finances. Councilmember Henderson's bill has a more detailed provision, and I think it'd be fine to include something like that in a bill. It would not affect the uniformity of the legislation to enhance that, because that's perfectly in line with the intent of the uniform UCANLA. is to encourage financial literacy by students, college students. So I think certainly that we certainly can make clarifications about whether setting up the marketplace is something that would be prohibited, make it clear it's not. And we certainly could add clarity about the prohibited activities if that's necessary. So, I mean, there's certainly, we as I said, I'd be happy to work with Councilmember Henderson and her staff and others, with, of course, with the help of Professor Feldman and Jerry Bassett to do something about this. So we certainly do see certain things that we could work with.
You'd mentioned the prohibitions, and I was taking a closer look at that. Well, Councilmember Henderson was asking questions, and I would think there could be a combination of both, and that is some activity that would be prohibited, like alcohol, tobacco, steroids, and gambling, and then leave it to the university's discretion whether there are other activities that are prohibited, and then requiring that the institution has to have the same policy with respect to its sponsorships. So sort of, I see a combination of all three.
And that seemed very sensible. We have to, of course, look at the details, the devil's in the details, but I think that's a good approach.
Are there other provisions that, how do I want to put this? Other provisions that you think we could work into this bill, into the uniform bill?
Well, those are the major ones. I did go through we did a very careful analysis and comparison of every provision of Bill 445 with 455 and 456 and put it in a table and a chart. I think one of the main problems is that 445 doesn't cover a lot of stuff that the others do, and I think the one additional thing about financial the literacy,
Financial literacy?
yes, of students. I mean, for the educational of students on finances, I think it's probably good for every young a person to have that education, but especially somebody who might be faced with getting compensation for NIL would be especially important. That I think is something we could certainly make it more robust to reflect something like Councilmember Henderson's. And the other ones I discussed too, basically clarifications, which I think all of these are in the same intent of UCANTALA. And the question is how much clarity and extra language do you want to put in it? But those are the basic things. I don't see anything others offhand. But that's what I see so far. Okay.
Councilmember Henderson, you look like you want to interject something.
I just wanted to ask a clarifying question, if I could. Mr.
Please.
McKay. So, Mr. McKay or Ms. Snyder, in terms of the uniform proposal of student athlete must disclose the NIL agreements valued over, was it $300? And then compensation over $2,000. What is the appropriate place for that? Where are we disclosing? To whom?
In 456, we contemplated that those disclosures would be going to like the athletic director or their designee. So somebody in the university compliance office would be receiving those designations. And I think that most universities that have an internal policy currently require disclosures to be done internally.
Okay. And Ms. Snyder or Mr. Feldman, I was sort of thinking about this because we have an institution in DC who just expanded a brand partnership. There's nothing that prohibits a student athlete from entering into an agreement with the same brand that the university already has an agreement with. So like their own separate deal.
Correct.
Okay. That was all. Thank you, Mr. Chairman.
Oh, your first question Councilmember Henderson made me think to ask Mr. Feldman. I think you're the UC AA compliance officer for your university.
Correct.
So does UCAA?
NCAA. I'm the
NCAA.
NCAA compliance officer at Tulane.
Yeah, I misspoke. Does the NCAA require a compliance officer at each participating school?
Require one who oversees NIL or just in general?
You are the compliance officer.
Yeah,
not-
well, so we have a compliance team that reports up to me in the provost's office. The NCAA doesn't specifically require that every school has a compliance officer, but there are significant compliance responsibilities. And so I'm not aware of any Division I institution that doesn't have at least one compliance officer, and many of the FBS schools will have 10, 11, 12 compliance officers.
Okay, so to answer Councilmember Henderson's question, it would be, we would have to wordsmith this disclosure to whoever is responsible for NCAA compliance at the university. I'm sort of looking for a nod. I'm getting a very shallow nod from Mr. Feldman.
Yeah, sorry, I didn't realize. Yes, yes.
Let me see what other questions I have. Ms. Kambula Fraser, how many athletes do you think we're talking about in the district?
Oh, goodness, Mr. Chairman, I would have to get back to you and would not want to share information that I'm not 100% sure of. But I should be able to, get that for you rather quickly.
Okay. See if I have any other questions. Give me a second here. Councilmember Henderson, do you have any other questions?
No, Mr. Chairman, thank you to all the witnesses.
All right, give me a second, everyone.
Mr. Chairman, I think you're muted.
Correct, because I'm talking to staff and I'm trying to understand this question I'm about to ask you guys. The question I'm struggling with is that, as I understand it, the uniform bill has a penalty in it. The civil penalty is something like up to $50,000 or $50,000. Am I right? It sent somebody off. Mr. Feldman, you're nodding yes.
Yeah, I was going to let Libby handle it. Looked like she was about to.
Yeah, in Bill 456, it's 47-2889.18 civil penalty.
May I add, this is a cap. This is an absolute maximum. It's on page 393 at C, but it's just it's a limit. It doesn't say you can do that. It's just that, depending on the damages, you have to prove your damages as in any civil litigation. This is just a cap.
Okay, how'd you come up with 50,000? And part of, just so you all know, not that I need to share this with you, is that I'm learning that the most famous case in name, image, likeness is Jim Brown. I'm like, what? Because he's from like the 1960s, but and that was $600,000, but that also was 50 years ago. So how do you come up with $50,000? Mr. McKay, you were muted.
I'm sorry, I would suggest that Gabe Feldman as a reporter would be in the best position to answer that question.
Yeah, I will tell you that the number as with other numbers in there, part of it is based on UAAA, and part of it is also, given that it's bracketed, the idea was, well, bracketed in our Uniform Act was to allow the state or the district to determine what the appropriate number was. And so 50,000 at least was not a magic number based on any specific data point with respect to name, image, and likeness. Obviously, the damages under the previous section, the civil remedy, could be higher than that, depending on the harm that is caused. But this is just the civil penalty that could be leveled on top of that. But if Libby or Jerry have anything to add, feel free to jump in.
Yeah, I was going to say what you said, Gabe, which is that the civil remedy section would allow you to go above that based on the damage caused, but the civil penalty would be capped at 50,000. But also, if that number needed to be changed, that's in your discretion.
Okay, let me check again, see if there are any other questions. Councilmember Henderson, last chance.
All good, Mr. Chairman.
Okay. I don't have any other questions. All of your testimony has been helpful. We're going to struggle with this, and we will reach out to the consortium or to the ULC folks as we need to, as we sort of work our way through this. I want to thank all of you again for your testimony and your time. And as I indicated at the beginning, the record in this matter will be open for 2 weeks. And that's really just for purposes of, we have to file the record, and so we have to have a cutoff date. Thank you again. The time is 2:18 in the afternoon, and this hearing is adjourned.
Thank you, Mr. Chairman.